The nature of a general partner's interest in a general partnership is sometimes nebulous and difficult to define. If there's a legal dispute between the partners, then it often gets hard to pin down their precise entitlements. The Tennessee Court of Appeals undertook to do just that in the case of Putnam versus Shoaf. The Frog Jump Gin Company, or Frog Jump, was a general partnership that operated a cotton gin in the 1970s. Initially, the general partners were E.C. Charlton, Louise Charlton, Lyle Putnam, and Carolyn Putnam. Each held a 1/4 interest in Frog Jump. After Lyle Putnam died, Carolyn, his wife, succeeded to his interest, giving her a 1/2 interest in Frog Jump. Frog Jump became deeply indebted to a bank, for which Carolyn wanted to rid herself of personal liability as a general partner. To that end, John and Maureen Shoaf agreed to assume Carolyn's partnership interest, as well as her personal liability for partnership debts, if Carolyn and the Charltons would each deposit $21,000 into the partnership account. After the deposits occurred, the Shoafs assumed Carolyn's interest in the partnership and its property, and, along with it, Carolyn's share of partnership debts, including those arising before the Shoafs entered the partnership. At the time, Frog Jump's only known assets were the gin, equipment, and the land where they were situated, all held in the partnership's name. The partnership then fired its bookkeeper and hired a new one. The new bookkeeper soon discovered that the former bookkeeper had embezzled money from Frog Jump using forged checks. In Tennessee State Court, the partnership sued both the old bookkeeper and the banks that honored the checks. The trial court permitted Carolyn to intervene and assert a 1/2 interest in any resulting judgment. Carolyn died while the case was pending, so her estate prosecuted the case. The trial court entered judgment for the partnership, and the banks paid over $68,000 into court. The Charltons received half this amount by agreement. Litigation then ensued over whether the Shoafs or Carolyn's estate should receive the other half. The trial court found for the Shoafs, holding that Carolyn intended to and did convey all her interest in Frog Jump to the Shoafs. She thus lacked grounds to reform her contract with the Shoafs and claim half the judgment. Carolyn's estate appealed to the Tennessee Court of Appeals.